And welcome. This is Mr. Perry, and we're going to be looking at the Dred Scott versus Sanford case, a landmark case in American history in our courts. And just some real quick background on Dred Scott. He was a slave originally born in Virginia. Now, the person that owned him eventually moved to the St. Louis, Missouri area. And while there, he sold Dred to an army doctor named John Emerson. Now, Emerson moved around a lot, working for the army and with the army. And he eventually moved up to Illinois at a fort called Fort Armstrong. And after they spent a couple of years there, they moved on to Fort Snelling. Fort Snelling was then a part of the Wisconsin Territory and is currently a part of Minnesota. Now, the thing with the Illinois and Wisconsin territories, these were slave-free territories. They were not yet states. They were territories, and slavery was not allowed in these territories, as they were part of a deal called the Missouri Compromise, which made territories above a certain area not open to slavery and below a certain area open to slavery. So with that, let's look at the facts of the case. Dred Scott, a slave in Missouri with the army doctor named John Emerson, and he eventually resided in Illinois, which was a free territory and part of original Louisiana territory, and slavery was forbidden by the Missouri Compromise, as we talked about, that compromise of 1820. And after returning to Missouri, and that was from the Fort Snelling area, they at first went to Louisiana, where Emerson met his wife, a woman named Irene Sanford. And Emerson actually died in Louisiana, and Dred had to go back to Missouri with Emerson's wife, the Irene Sanford. And while he was there, he wanted to obtain his freedom and asked, now that Emerson was dead, could he become free? He'd pay for it even. And Miss Sanford said, no. You are owned by me, and I'm not giving you permission. And he said, that is Dred Scott, well, I was in a free state or a free area in Illinois and in Wisconsin. That means I should be free. Well, of course, Miss Sanford disagreed, and they wound up in court. And Dred Scott lost. And we'll pick it up here. It says, after losing, Scott brought a new suit in federal court. And Scott's master, Sanford, maintained that no Negro or descendant of slaves could be a citizen in the sense of Article 3 of the Constitution. So the question was Dred Scott free or a slave? Well, our esteemed judges came up with a conclusion, and the conclusion said by a 7-2 decision that Sanford, they ruled in her favor. And the majority opinion was by Roger Taney. And it held a portion of the Missouri Compromise, that 1820 compromise that we talked about, which was passed by Congress. They said it was unconstitutional and it was in violation of the Fifth Amendment, treating Scott as property and not as a person. Well, let's read a little bit about this decision. The majority held that a Negro whose ancestors were imported into the U.S. and sold as slaves, whether enslaved or free, could not be an American citizen and therefore did not have standing to sue in federal court. Because the court lacked jurisdiction, Taney dismissed the case on procedural grounds. What he was saying there is, well, if you're black, you can't be a slave. So if you can't be a citizen, I should say. And if you're not a citizen, you can't bring a case to the Supreme Court. And being that he's not a citizen, this is null and void. You can't even bring this to court. I can't even rule on this. Now, Taney further held that the Missouri Compromise of 1820 was unconstitutional, saying those Congress people had no right to vote that you could have certain areas that didn't have slavery, and foreclosed Congress from freeing slaves within federal territories. They said, if you're not a member of a state, then you are not have jurisdiction. Well, the opinion showed deference to the Missouri courts, which held that moving to a free state, like he moved to Illinois and Wisconsin, did not render Scott emancipated. That is, he couldn't be free. Finally, Taney ruled that slaves were property under the Fifth Amendment, and that any law that would deprive a slave owner of that property was unconstitutional. Now, the way that the Fifth Amendment read, and this is just a little part of it, it says, a person shall not be deprived of life, liberty, or their property. In other words, if they were to give Scott his freedom, they would be depriving Miss Sanford of her property because he was owned by her. So Taney ruled that the slaves were property, and there's nothing that he could do about it. Now, the dissenting parties, those are the people who didn't agree with it in the court, were Benjamin Robbins Curtis, and he criticized Taney for addressing the claim's substance after finding the court lacked jurisdiction. In other words, if you didn't say that he had the right to even bring it to court, why did you rule on it? You should have said nothing. He pointed out that invalidating the Missouri Compromise was not necessary to resolve the case, and cast doubt on Taney's position that the founders categorically oppose anti-slavery laws. And what he was saying there is there's nothing in the Constitution that the founders of this country, there's nothing that says that you can't make something anti-slavery. It doesn't say that. John McLean echoed Curtis, finding the majority improperly reviewed the claim's substance when its holding should have been limited to procedure, the same thing as Curtis said. If you didn't think he was a citizen, you shouldn't have ruled on it. He also argued that men of African descent could be citizens because they already had the right to vote in 5 states. So what do you think? Did they have the right to do it? Did they have the right to declare it unconstitutional? Well, this case was later overturned after the Civil War when African slaves former slaves were allowed to be citizens. And this turned out to be a black eye on the Supreme Court and really kind of showed the worst that the American court system could offer to its citizens. So we have some questions associated with this. Take a look through them, answer them, and get it done. Hit it and quit it.